Good morning once more. My name is Diane Onditi from Kenya National Chamber of Commerce and Industry, and I'd like us to begin the webinar. MMW are members of KNCCI and they're the facilitators of this webinar. We look forward to having a great session. Thank you. I'll let the MMW team introduce themselves.
Good morning, everyone. I hope you guys had a wonderful morning. My name is Oscar Wandera. I'm an associate advocate at MMW Advocates in the Litigation and Disputes Resolution Department. I think I'll hand over now to Brenda and Faith to introduce themselves.
For that, my name is Brenda Kirimi. I am an advocate of the High Court of Kenya and a certified data protection officer. In addition to that, I'm a certified legal auditor. I'll be one of the speakers for today's session. I'm looking to an engaging interaction with all of you. Faith?
Now I'll hand it over to Brenda to introduce herself.
Good morning once again. My name is Brenda Kirimi. I'm an associate with Commercial, Conveyancing, and Corporate Department at MMW Advocates. In addition to that, I'm also a data protection officer and a certified legal auditor. I'll be one of the speakers for the purposes of our conversation today around data protection and employee privacy. Welcome all, and I look forward to an engaging session. Okay, noting that Faith is not in the platform at the moment, I'll just proceed and introduce the firm.
Brenda, I'm in, sorry. Am I now audible well? I'm now well and audible enough?
Yes, we can now hear you. Thank you for joining.
Thank you.
Faith, you can proceed and introduce yourself.
Thank you, Brenda, and really sorry for this short pitfall that we just experienced this morning. My name is Faith Chebet, and I am an HR by profession, currently working as an HR manager with Public Service Club. Looking forward to this exciting session and looking forward to a very engaging session with our audience here. Asante sana, Brenda, over to you.
Thank you so much, Faith. So MMW Advocates is a boutique law firm located in Kileleshwa in Nairobi. We have several departments, including Employment Relations and Disputes Department, ESG, Tax, IP, Real Estate, Commercial, Corporate, and Conveyancing, which is part of real estate. So the firm's mantra is embracing and solving the complex. Our vision is to be Africa's hub for legal solutions. In the course of practice, we've received several accolades, and a number of them are listed on the screen shared. I'm not going to go through them, but we pride in bringing practical solutions to our clients. So I'm going to proceed and to our conversation today, and we'll start with discussing why we are having this conversation today. Why does it matter to you as an employee, or why does it matter to you as an employer? So basically, data is a cornerstone of every employment interaction, from the point of submission of a resume to asking for employee personal details when you're attending to execution of contracts and all. And basically, when an employee is giving their details to the employer, this is based on a trust that their personal information is not going to be leaked, and it's not going to be used for purposes other than those which the information was shared with the employers. Then for employers, it's a matter of reputation, it's a matter of compliance and risk mitigation to ensure that the employer is not exposed to legal and financial liability owing to non-compliance with data protection laws in the country. Further, for employees, it's an issue of their rights. And for purposes of our conversation today, we are specifically going to focus on the right to privacy, which is enshrined in Article 31 of the Constitution of Kenya 2010. There's also the right to human dignity, which speaks to the nature of the information that the employee shares with the employer. So we're then going to look at what we are going to gain from having this discussion today. And I would like to frame it in 5 points. The first one being that we are all going to get an understanding of the legal framework around data protection in Kenya. That is the Constitution of Kenya and the Data Protection Act. We are also going to get a deeper understanding of how data protection laws apply directly to human resource information management. Thirdly, we are going to get practical insights on measures and safeguards that employers and even employees can implement at the workplace to ensure that the sensitive data of staff members is well protected. We're also going to get to appreciate the fact that data protection in human resource information management is a shared responsibility for the employer and the employee, such that the employer is going to put in place appropriate measures to make sure that the personal data of employees is protected, and the employees are part of the team that will ensure that these safeguards are actually implemented by aligning with the policies that are in place. I know I've already touched on aspects of the legal framework for data protection laws in the country. So our conversation today is trying to understand how data protection framework and the employment relationships interact, the responsibilities of an employer under the Data Protection Act, and also I would say the responsibilities that accrue from the Employment Act. So by just the virtue of the superior position held by employers in employment, they determine to a very large extent the kind of data that they're going to collect from their employees. And in most cases, the employees really don't have a choice. You just have to supply the information that you have been asked to give. And that is why the law has put in safeguards to ensure that it strikes a balance between the rights of employees as data subjects and the rights, or rather, and also obligations of employers. So we are now going to appreciate what are the provisions of the Data Protection Act. So the Data Protection Act defines key terms, amongst them data subjects, sensitive personal data. It also establishes the Office of the Data Protection Commissioner, which has been very instrumental in shaping the landscape in terms of data protection in the country. We're also going to look at the obligations of data controllers and the principles of data protection and the rights of data subjects. So I'm now going to proceed and define a few terms that throughout the speakers will be referring to. So the first thing we need to understand is what we mean by personal data. So personal data is any information relating to an identified or identifiable natural person. In this case, it's any information relating to an employee. Then we are now going to define data subjects, which refers to a natural person, that is an identifiable or identified natural person who is subject of personal data. And I would like you to note that it refers to natural persons. There is a decided case on the place of body corporates in relation to them being whether or not they are a data subject. And in that decision, it was decided that body corporates are essentially not data subjects within the meaning of the Data Protection Act. The other thing we're going to define is what we mean by data controller. So a data controller is basically an organization entity. This could be a private or a government organization that determines the purpose and means of collecting personal data. Then we have data processors. These are people, these are organizations or persons who process data and on behalf of the data controller. The other definition is processing. This one I would like to define it as any act performed on personal data, because basically everything that you're doing with respect to an employee's information is processing. Then we have the concept of sensitive personal data, which is a special category of personal data to which a higher degree of protection is accorded. So the Data Protection Act and lists a number of information that qualify as sensitive data. And under Section 45, the Act actually prohibits processing of sensitive personal data unless an organization is compliant with the principles of data protection. And further, whenever you're processing sensitive personal data, you're supposed to seek the consent of the data subjects and ensure that maybe practice is carried out in the course of legitimate activities, having put in place appropriate safeguards. Then, of course, when you're processing sensitive personal data, you have to make sure that you're observing and respecting the rights of data subjects. So we can now proceed and discuss the principles of data protection. So these are basically the principles of data protection we generally discuss whenever we are talking about data protection. But in this case, we are going to discuss them in the context of human resource information management. So the first principle is the principle of lawfulness, fairness, and transparency. So what this basically means is that employers must process employees' data legally, fairly, and with full disclosure. So this principle basically requires you to inform the employee why you're collecting the information, seek consent from them, and put in place measures to give them the option of opting in or out when the purpose for which you collected the data has changed. The next principle is purpose limitation. So basically, data should be collected for specific, explicit, and legitimate purposes. Any actions beyond the performed by an organization beyond the purpose for which data was collected breach this principle. The third principle is data minimization principle. So this principle basically requires you to refrain from obtaining unnecessary information from employees, that is as an employer. So for this one, I would like to give you an example with a scenario when you're recruiting. So an employer really ought not to ask for the medical records at the point of recruitment, because at that point, information on an applicant's medical records is not necessary. Then the fourth principle is accuracy. So basically, the employer is supposed to ensure that staff records are correct, updated, and there are measures to identify incorrect information, delete, and where the information is incorrect, delete the same and have the same updated. Then we have the principle of storage limitation. So this basically requires employers not to store employees' information beyond a certain statutory timelines. For instance, information relating to the contract of employment should not be stored for a period exceeding 5 years after the employment relationship has ended. Then we have a sixth principle, that is integrity and confidentiality. So employers are basically required to protect sensitive employee files from unauthorized access or accidental loss, and lawful processing and such things. So An employer should have measures to make sure that employee information is not unnecessarily disclosed to parties who ought not to be privy to the same. You can maybe use measures like encryption, password, such that, for instance, human resource information like my identification documents, my KRA pins, those are things that every employee in the firm need not to, or whatever workplace you're working, need not to have. So there should be measures to make sure that such information is only available to maybe the people in the human resource department. Then we have a seventh principle, which is actually an obligation of data processors and data controllers. So this one basically requires the data controllers and processors to be able to demonstrate compliance with the Data Protection Act. So I'm going to give you an example with the requirements for registration with the Office of the Data Protection Commissioner if you're a data controller or a data processor. So an employer should be able to demonstrate that they have registered, and this is by way of a certificate of registration, which is usually valid for 2 years. The other thing is maybe with regards to the obligations of having a data protection officer. So if an organization processes large-scale systematic monitoring or processes large-scale of sensitive data, they are required, okay, it's advisable under the Act for them to appoint a Data Protection Act. This obligation is, however, not mandatory. But it's advisable that where there's a risk of, where the organization is aware that they are processing a large scale of sensitive data, systematic monitoring of their employees, they should have a data project. So these are things that basically the organization is supposed to be able to demonstrate by providing substantive evidence whenever called to do so, which actually the Office of the Data Protection Commissioner can do under the Act. Then we are now going to look at the rights of data subjects. I'm going to start with the right to be informed. So employees need to be informed how their data will be collected, stored, processed, and for what purpose their data is being collected. The other thing is the right to access. An employee can request to see their personal file or payroll records held by the Human Resource Office. And where an employee requests for such information, the employer ought to disclose and share information that they actually have regarding this employer. The other thing is the right to rectification, that is correction. So you're going to realize that most of these rights are related to the data protection principles. So the right to rectification basically requires that where information regarding the employee maybe has changed, for instance, their address or such things, you should be able to have a mechanism through which you can update the information. So employees can request for rectification of their personal data. The other thing is the right to erasure or the right to be forgotten. Employees can request for the deletion of their personal data when it's no longer necessary for the purpose for which it was collected or post the employment contract, though the Act lists other grounds on which the right to be forgotten can be exercised. The other right is the right to restrict processing. So an employer can request a restriction on the processing of their personal data where accuracy is challenged or where the personal data is processed unlawfully. So they can also request for restriction of processing where they need their personal data to establish or defend legal actions. And another instance given by the Act is where there is an objection and the data subject, the parties require the personal data to establish whether a legitimate interest exists such that the interests of the employer can override the rights of the data subjects. Then we have the right to data portability. So the employee is entitled to receive their personal data in a structured, commonly used, and machine-readable format. And so in this case, we have basically the employer should be able to avail the information to the employee in a machine-readable format. In some instances, we say that an employee can request for even the transfer of their data from the current employer to a new employer at the point where the employment relationship is terminated. Then we also have the right to object. So an employer has the right to object at any time for to the processing of their personal data on the grounds of legitimate interest, or for where their personal data is intended to be used for direct marketing. Then we have the right not to be subject to automated decision making. So employees have the right not to be subject to decision based solely on automated processes, for instance, AI, and also to request for human intervention. Then employees have the right to lodge a complaint in cases where their personal data, their rights have been violated. They can lodge a complaint with the Office of the Data Protection Commissioner. So that's it from my end. I was just trying to lay a legal basis of the provisions of the law with respect to data protection, and our conversation today. Faith will now take us through data protection from a human resource perspective.
Thank you, Brenda. I suppose I'm quite audible now.
Yes.
Thank you. Thank you, Oscar, for confirming this. Yeah, so I would want us to see the HR perspective. We've been taken through from the legal framework. So I would want our discussion to be as very practical as possible. We are going to really see how the HR handles employee data, and we are going to assimilate it to the data principles that Brenda has already brought it up, and how we can relate it to from the legal framework. So we are going to see through the employee journey as an HR, and how we are going to really ensure that we are compliant and legally protected matters to do with HR. So data protection in HR has really evolved, and it's legally managing employee information through the employee life cycle. Matters to do with recruitment, employee management, payroll, disciplinaries, performance appraisals. We're going to see how all these, what we are required as HR professionals to be able to be compliant with the Data Protection Act of 2019. As we can see, we as HR professionals really handle very sensitive data of the employees. We handle things to do with their personal lives, their marriage lives, their marriage status, their pay, their contract clauses, and even through their exits. So most of the items, you're going to see what are some of these sensitive data that we as HR handle. I would want by the end of this session, we'll be able to understand the Data Protection Act from the HR perspective, analyze the HR responsibilities across the employee life cycle, identify organizational risk and exposures that we as HR need to be informed prior to our day-to-day operations in the offices. So poor handling of employee data exposes the organization to legal mitigations and even damage the brand of the organization. Those are some of the items that the HR handles through the employee life cycle. I've already mentioned. So we can proceed to the next slide. So I would want us to see from what angle do we, as with the HR, as a governance action. Remember, even as the things that we do in our offices or in our places of work, we're able now to ensure that we are compliant. We're able to ensure that we are compliant in every aspect of our day-to-day operations. So As an HR as a governance function, we need to obtain employee consent. We manage the employee consent management, data protection governance, confidentiality controls, access management, privacy notice and transparency, and compliance coordination even with the legal team. So those are some of the areas that we as HR need to be very, very conversant about. So let us now take ourselves through the employee life cycle, and we're going to start with recruitment. I want us to be very practical. Let us just be very practical in a way of how we recruit, from the job adverts to pre-employment, to onboarding, to issuance of our contracts, to now induction and to exits. Now, I can take this back to as the HRs. What are some of the prerequisites that we should be compliant about even during at the initial stages of recruitment? I would want us to see an example. I recently went through the Safaricom recruitment portal, and I was able to look at the consent bit, where we are consenting. We seek consent from the from the candidates that in whatever information they're going to avail during the recruitment is purposely for that job, is purposely for the purpose of recruitment. That is one of the compliance bits that we the HR are able to look at, so that we're able now we are in a position to offer confidentiality and integrity to our candidates. We are able to collect the items that we collect during the recruitment are things to do with maybe CVs, IDs, academic records, reference and assessments. So we as the HR are even already exposed to the manner in which we collect this data. So the data requirements at this point are things to obtaining consent before collecting and processing data. So we can look back at our workplace and see how compliant are we at this point. Do we have an employee consent where we're able to consent and we're able to get permission from our candidates that we are assuring them of confidentiality and purpose of limitation to the data they're going to avail to us. Inform candidates how their data will be used. We also have the privacy notice. Use data only for the recruitment purposes. We're able now to be able to associate these with the principles of data protection that Brenda had already given to us. Purpose of limitation. We should only be able to collect data limited for that purpose, and do not retain unsuccessful candidates' data indefinitely. Back to us, the HRs, for how long are we able to, for how long are we legally required to hold employee data? I've read some of these cases in the recent past, and I saw a ruling of 6 years, but let us engage this during our Q&A session, where even our legal team can be able to confirm this. At what period are we able to hold employees or candidates' data indefinitely? The HR risks at this point are things to do with sharing CVs internally without restriction. We should be able to be compliant enough in a manner that we only use the CVs and the data recorded for the limited for the intended purpose. Retaining unsuccessful applications indefinitely, those are some of the risks that we HR are exposed to, and we should work our ways out and see that we're truly compliant to this aspect. Some of the controls that we can put in place during the recruitment process in matters to do with the HR, with data protection, items to do with the recruitment privacy notices. Probably we come up with the notices to our candidates on matters to do with, is my volume okay, Oscar? I can see some of our audience are seeking for the volume. You able to hear me quite well?
Yes, you're quite audible.
Thank you. Consent before processing the candidates' data. I think we've discussed this over and over again. Retention policies for unsuccessful applicants. Probably for those of us who've not been able to be compliant with this sector, we can be able to research further on how we can be able to come up with policies that should guide us so that we're not legally exposed on matters to do with recruitment and selection in data protection. We proceed, we look on the other aspect of employee records management. Some of the items that we put in our custody as HRs are things to do with employee data, IDs, their spouses, their families, their married status, their care rates for payrolls, PIN, NSSF. We're also in custody of the contract and salary information of our employees, next of kin details, medical and disciplinary process. Now, we're able now, we can see at this point that we really hold a wide scope of employee data. So it is now up to us to ensure that we are up to game on matters to do with the exposures of data, so that we'll be able to be able to know and expose to what extent are we the HR, to what extent are we exposing our organizations and our employers to matters to do with data protection. And I think we've seen in the recent past how employees are nowadays very much informed. We have so much avenues of learning these items, and we can only be smart on how we handle employee data. So some of the data protection requirements at this point in employee records management ensure confidentiality and restricted access. We've seen, I've worked in many of our offices of the HRs. We have a lock and key cabinet files. Of course, we have our HRIS database systems, but how safe are they? Have we been able to put and equip restricted access controls on these data storage equipments? Collect only data necessary. If we're processing data to do with medical, let us only process data restricted and limited to medical cases. If there are things to do with data performance appraisals, we should be able to collect data only purposes, and that's only limited to that purpose. We see we can be able now to associate this employee life cycle to the data principles that we have. We have attempts to do with the data limitation, access controls for the intended purpose, the confidentiality. We can see how we can now resonate and see how are we associated with these data principles even in our day-to-day operations. In employee data management records, where the HR risk that we are able to, that we can see that probably we could be exposed to some extent, is open access to HR files. I've also gone to some areas, to some offices, and see our offices are quite open to everyone. You see, that is where we keep our files. That is where we keep our entries and outries. Probably we can seek support even from our employers and our bosses. And give them a very good reason why we need to have an access even control even to the HR offices, because we are storing a very sensitive HR data. Poorly secure digital systems. I don't know how secured, how have we encrypted even our databases to ensure that we only have a restricted access controls to employee data. And even control measures that we can be able to put in place on that aspect is a role-based access control. I know Oscar is going to put it up quite very well. Secure storage or locked cabinets, passwords, and encrypted access controls. We go to another aspect of employee life cycle. Let's look at payroll and benefits administration. Probably this is also a very wide area in matters to do with HR. And most of the sensitive payroll data that we hold at this point are bank details, tax information, and salary records. We go to an extent of even holding the employee salary information, the contract details, and probably over to us, the HRs. I have seen most of our contract now has a data clause, data protection clause. We could be able to see how we've really put forth the wordings of that data clause, so that we are legally binded on matters to do with data protection and data details from the employees. To some extent, I know we've had many court cases coming up, and we should be in a position now to day in, day out, try see how we're able to keep trend on the emerging cases and data to do data protection. But one of the measures or mitigation that we can put in place is having that data clause protection even in our employment contracts. So at this point, the data protection measures are items to ensure secure processing and transmission, especially having a third parties like the banks, the vendors of the banks, our medical scheme providers, our suppliers, and all that. So how do you have SLS? Do you have SLS with our vendors? in matters to do with data protection? To what point have we as HRs ensured that our organizations are legally protected from exposures of exposing employee data to the third parties like the suppliers and the service providers? So that is an area that we also need to sit and look and see how exposed are we. Share data only with authorized third parties. If the intended purpose is on matters to do with payroll and payment of employee salaries, let us share data only to the banks. Let us not be in a position to divert and give data elsewhere that is not intended for that purpose. We can see how we are now associating the data principles in our day-to-day activities. Have data processing agreements with vendors. I think I've talked about the SLAs. The major HR risks at this point are secured email transmissions and vendor misuse of employee data. In the recent past, I saw a case where an employee was using a personal Gmail for work errands. That is actually at this point, I think the legal team here can confirm to us that I don't think that is a good practice. We should be able to have and really convince our employers that let us be confined. Let us, these are some, I think, do we have enough resources provided to our employees? But by the time someone is using a personal Gmail to really work errands, that is really not, that is quite unethical. And I think we should be able to see and convince the employer to how badly we are exposed in matters to do with the HR, with data, with HR data exposures. The strategic controls at this point maybe is to vendor due diligence. Have we been able to do a background due diligence of our of our vendors in matters to do with data protection, and even the how secured is our data? Data processing agreements and encryption and secure payroll systems. We have discussed this at length. The other aspect is items to do with performance and performance management and confidentiality. This is also an item that I would really want us to engage during the Q&A session. We, as the HRs, I know we do understand how performance management system works here. How, to the extent to which data is being transmitted from the employee to the line supervisor to the leadership, how when you're seeking the training budgets, we need to convince the employer. We need to provide data to the employer on the reasons why probably we need to do a training. We can see how the transmission of those data in this practice so much has a very wide scope. So maybe this can be a discussion during a Q&A session. Well, to what extent are we legally protected in matters to do with transmission of data, especially during for the performance management, and what we need to put in place as HRs to ensure that we are really secured. The data involved at this for this function: performance reviews, disciplinary records, feedback notes. Actually, I think 3 months ago, there was a court case where an employee was seeking a legal redress on how her information was exposed actually to the directors, and the director and the employer now was seeking actually an exit leeway for this particular employee. And at that point, I think the line supervisor had even proceeded to enroll on a PIP. There was even a notice improvement on the case. And at that point, coincidentally, the directors had already initiated an exit process for this particular employee. There was at this point, we can see there was a mishap, a disconnect of communication between the HR, the line supervisors, and the directors. So probably this is an aspect, I think, Brenda and the team, that we really need to look at, maybe even if not today, in the future. To what extent are we, the HR, still need to be very equipped on matters to do with data protection? Very quickly, we can look at data protection requirements at this point. Maintain confidentiality of evaluations. But to what extent are we maintaining confidentiality of evaluations if we actually need to convince the leadership on a training budget? We need to avail these informations to them. That's an area of discussion probably. Ensure fairness and accuracy. Of course, this is an aspect of confidentiality and accuracy of data that we even collect during the performance appraisals. Avoid unauthorized sharing of performance data. This is quite huge in the HR space. The organizational risk at this point is informing or sharing of appraisal informations, biased or inaccurate evaluations, and the best practice at this point probably is to standardize evaluation systems and rule-based access controls. We proceed to the other aspect of the employee lifecycle training and development. This is more related even to performance management. And I think probably we can even just see the HR responsibilities at this point. Inform employee when the data is shared externally. Now, these are some of the mitigations that probably we should need to put in place. This and more out there. Are we at any given point? Do we have a discussion with our employees on how our data is shared, even to the other parties, and for what reasons? Share only necessary data, share only necessary data to the intended recipients. Protect training assessments and development plans. The HR, of course, risk at this point is sharing participated data without consent. I think this is where that particular case really went wrong. And the control measures at this point is training data privacy notices even to the leadership, to alliance supervisors, and to the head of departments. Minimal data sharing with the third parties. Only use the data intended for reasons probably to get the training budget. Let us be very limited to how we share data and the accuracy of data, and share data only intended for that purpose. Very quickly, we can proceed to the last aspect of employee separation and exit management. This is quite very interesting. And even before I start it, just as a case scenario for us to be able to really understand this aspect, there was a court ruling, I think 3 weeks ago, probably, maybe, where an employee had exited an organization. And unfortunately, the employer used his or her image for commercial purposes, for purposes of advertisements. So this particular employee went to court, and the court ruled on his favor. I think he was given a very hefty compensation. So back to us HR. When do the consent of usage of employee data cease with the employees? Is it upon withdrawal? Is it upon when the employment ceased to exist? Probably this is an aspect that we can discuss during our Q&A session. But also it is an avenue where we really need to sit and look to what extent are we exposed? When do we break the bonds? When do we tie the bands between the existing and the exited employees? So what data handle? What type of data do we handle during employee separation and exits? We exit interviews. We have the clearance forms. We have the final dues and records. Back to us also the HR. How do we conduct the clearance processes? Most practices that we do is an employee is required to clear with every department. So how is the confidentiality of that process also protected at this point? And the final dues records, data protection requirements at this point maybe to retain records only as required by law. The aspect of indefinite, the aspect of how long should we be able to keep employee records upon exit? Secure archive or dispose data. How do we dispose our data? Do we do the shredding? Do we have the archived aspect of where we dispose our data? But how safe and secure is that process of even disposing the data? Maintain confidentiality post-employment. How is probably these are aspects to do with even during the reference check. Some of the employers require an information from the former employer. So what is the best practice of which the HR need to put in place to be able to ensure that we only display information intended for that purpose? So HR is at this point maybe to keeping unnecessary records indefinitely and improper disposal of sensitive documents. Some of the controls we need to put in place here are the data retention and destruction policy, and control archiving systems. We proceed to the next slide of the checklist now. Let us summarize and sum up this aspect of what are some of the compliance aspects that HR needs to put in place to ensure that we have that we are compliant with data protection. Obtain employee. This is just a consent. Obtain employee and candidate consent before processing data. Let us always be informing our employees, the candidates, the exiting of employees, the current employees. Let us always be updating our records. And by the way, as a good practice, we as HRs, I've seen even this really being exercised by most of us. How often do we update our employee records? How often do we do to ensure that we have the accurate data from our employees? And at that point, probably we should also be seeking consent, fresh consent from employees. Obtain employee and candidate consent before processing data. That is one of the checklists that we need to have. Number 2, issue privacy notices and communicate data usage clearly to employees. This, I see most of us practice this during the town halls. We maximize that time that we need to, we maximize the times that we have employees together, maybe during the town halls, the staff meetings, short notices to our employees. Actually, a very recent practice that I have seen is when we have these organizations where we are able to, we do birthday wishes to our employees. Then we have a very short note to our employees, matters to do with data protection, seeking consent maybe of an upcoming event. You see, we keep pace with the changing trends in data protection. Restrict access to employee records and payroll information. Let us only have persons who are authorized to access those data or any sort of employee files. Let us also be able in a position to let us be in a position to ensure that we've really restricted the access. We also have an aspect of protect HR data using secure systems and confidentiality controls. I think we've discussed this at length, and thank you so much. Thank you for this particular session, and I hand it over to Oscar to proceed now with the legal view of how we view the HR data. Oh, we still have more. Retain employee records only for legally justifiable periods. This is something that also say that we can have it as a discussion during our Q&A. For how long are we legally obligated to hold employee informations? I have seen 6 years, but I stand corrected even by the legal team here. Manage withdrawal of consent during exit management, very, very, very crucial. We've seen most organizations really exposed at this point. When do we cease the contractual data usage with our employees during exits? Let us be very compliant with this and come up with notices and policies that should protect us from this. Align HR, ICT, legal, and management data governance. This is where the HR comes in handy. What governance do we do? Do we have notices? Do we have privacy, consent from employees? Do we have access controls? This is where really governance comes in as HRs. And lastly, conduct regular HR data audits and staff awareness training. Let us maximize those times that really have employee gatherings, have said over again during town halls, staff meetings, and parties and all that. We can have a very short time, and let us make this very often. When we make it very often, we make it so known to our employees. But most importantly, we can be able to slot ourselves, and even during our to-do list, a way of how we could be able to audit our HR data and see where we have where we are compliant, and where we are not compliant, we could be able to do so. And probably where I've also seen it come out very strongly are items to do with when the notices expire, the expiry of the notices, and how we are updating our notices on all these employee cycles. Thank you so much. Over to you, Aska.
Thank you very much, Faith, for that detailed presentation. It was very informative. And also thank you for touching a little bit on what my presentation will entail. So my presentation essentially will entail covering case scenarios and advising on best practices. And you will realize that in my presentation, it will be more focused on what, as employers or data processors, what you need to look for and what you need to do so that you can avoid a liability. So in the interest of time, allow me to move very quickly. Now, my case scenario presentation has been segmented into 4. I'll address as a case scenario during recruitment, a case scenario during employment, a case scenario that deals with post-employment. That is once as an employer and employee have separated. So the first case scenario is ODPC complaint number 1532 of 2025. This is a case where we had a job seeker who had applied for a specific role at a specific company. However, the recruiter shared a CV with other third parties who are offering the same role for her to be able to take, and this was done without the consent or knowledge of the job seeker. So the Office of the Data Protection Commissioner penalized the respondent in this matter with a fine of Kenya shillings 262,500 for based on the fact that they didn't obtain the job seekers' consent. So the lesson, the takeaway in this presentation is that you cannot assume consent. You have to ensure that for you to be able to process somebody's data, for instance, their CV, you have to ask yourself some 3 critical questions so that you can be able to be compliant with the Data Protection Act. So you have to ask yourself, have the prospective candidates been explicitly informed about how their data will be used? Remember, one of the principles of data protection is transparency. So my presentation is also going to be tied very closely with the principles that my colleague Brenda has discussed. So you have to ensure that prospective candidates have been informed that about how their data will be used. Secondly, you have to ensure that you obtain specific, informed, and documented consent. Documented consent obviously is to help to shield you from liability and ensure that at least there's some evidence somewhere that you obtained consent so that you process the data lawfully. Informed, as I've explained, it's about the question of transparency, and specific is essentially informing the candidates the precise data that will be collecting and what we'll be using it for. The last question you also need to ask yourself is, can you be able to demonstrate a lawful basis for every instance of data sharing? So some of the lawful basis we'll discuss in my best practices, but we can go through some of them. One is, necessity. If you're required to comply with the Employment Act or the tax laws, or contractual necessity, that is, you needed the information for purposes of getting into an employment contract with the recruiter. Now, the second aspect of the second scenario is now during employment. And the case scenario in this case would be ODPC complaint number 0627 of 2024, where we had an employee's data, that is the employee's photo, was used by the company in marketing materials, calendars, and public signposts. Now, this was done again without obtaining the employee's consent. So the employee moved the Office of the Data Protection Commissioner, and the consequent effect was that the employer was penalized 500,000 Kenya shillings, which is indeed a hefty fine in this case. So the Data Protection Commissioner is very strict when it comes to enforce in terms of enforcing the Data Protection Act, and it's important that we try to avoid these kinds of liabilities, and especially where there are things that you can do, there are best practices that you can employ to avoid these kinds of scenarios. So what the takeaway for you in this is that you have to ensure that you obtain consent before using any employee's data. So the best way for you to do this is probably in the employment contract, you need to inform them that their images or whatever they'll be producing is going to be processed in a certain manner, maybe for campaign for marketing purposes and other purposes for the employer. Secondly, you need to understand that consent is not implied by virtue of an employment relationship. The idea here is that for every data that you collect from your employee, you must ensure that they're informed and they've given express consent. And now this brings us to one of the most critical aspects about consent, so that you may be able to be compliant with the Data Protection Act. So the consent that you obtain from your employee must be informed. And I think we've discussed this, that ideally you have to tell them what data you're collecting from them, what purpose that data is going to be used for, and if that data is going to be shared by any other party to any other third parties, they need to know, and they also need to know who these third parties are and what they're going to do with their data. Consent has to be expressed, as these case scenarios have demonstrated. Consent cannot be implied. The employee has to give express and unequivocal consent so that you can be able to shield yourself from any kind of liability. So the consent also has to be freely given. So ideally, this is now the employee has to ensure that he or she has voluntarily given their consent so that their data can be processed. The third case scenario is about workplace monitoring. Now, many organizations, I think, believe banks have come up with workplace monitoring processes, ideally to monitor fraudulent activities that have been going on, especially the banks which have really suffered on this question. So they've employed AI tools in a bid to enforce workplace monitoring. So for this, I'm going to discuss a decision by the Employment and Labor Relations Court. That is number 1644 of 2017. Now, in this case, the claimant lodged a claim against their former employers alleging unlawful and unfair termination of employment. And one of the grounds she afforded in terms of supporting a claim was that the evidence that was obtained by the employer, which evidence was used to terminate her, was procured illegally and in breach of her fundamental right to privacy. So what ideally happened here is that the claimant had logged in her personal emails and WhatsApp on the workplace system and tools. So this is like the computer, the office laptop. So in this case, there's a general jurisprudence that has come out from our Employment and Labor Relations Court that have said that you cannot say that an employer has violated an employee's right to privacy, especially where the employee has logged in her personal, social media accounts or personal emails on the employer's computer. So the court's holding in this case was that the court dismissed the unfair termination claim of the claimant on grounds that electronic communication systems and equipment that are issued at the workplace remain the property of the employer, and the employer ideally retains the right to track the use of this facility. So this is an important decision which ideally comes to protect the employer, where they have given workplace systems and tools to the employees to use. Now the last stage is the post-employment stage. Now this is where the employee has separated the employer, and we'll make reference to the ODPC complaint number 0213 of 2016. So in this case, the complainant had already left the microfinance bank, the employer. And once he left, the respondent, in that case, went on to run highly sensitive public notices on their social media platforms, complaining that the claimant was not part of them and warned the public ideally against transacting with him. Now, this was done. This is now the campaigns. They were done without obtaining the former employee's consent. And in this case, the Data Protection Commissioner was very punitive in terms of the sanctions in which he imposed. What he did was to recommend prosecution of the respondents' directors for obstructing the Data Protection Commissioner. And this ideally was because the complainant was able to demonstrate that the data that was released on the social media platforms was not released with his consent. And why the respondents' directors were sanctioned this heavily was because they were issued with a notice of complaint and they failed to respond. So this ideally also informs you that once you receive this kind of communication from the Data Protection Commissioner demanding you to answer to a claim, it's important that you comply to avoid these kind of punitive sanctions being imposed upon you. So the last segment of my presentation will be the best practices during recruitment. I believe Faith touched on some of these points. And the first thing is that the best practice in job advertisements, what does that entail? So you need to avoid requesting for excessive personal or sensitive data. So collect only what you will require to process an applicant for a job. The idea behind this is to reduce liability on the employer, because you see, the more data you collect from an employee or a prospective employee, there's a risk that you're going to process that data in some way or form. So for you to mitigate this risk is to limit the information that you collect to only what is required to process an applicant. You also have to state the purpose for which you will use this data that you've collected from prospective applicants. And the idea here is to promote that principle in data protection of transparency, which will also help you to avoid legal liability in case, as an employer, you are forwarded to the Data Protection Commissioner. So you also have to specify official requirement channels and limit access to only those participating in interviewing and recruitment. It's very important. For instance, if a department is recruiting, we can limit the people who have access to prospective applicants' data to maybe the HR personnel who will be conducting the interviews together with probably a head of department, so that you can limit the exposure of an employee's data, so that you can also avoid any liability in case that arises. This is now just a best practice. You can need to warn candidates against potential fraud in recruitment. You know, there are some agencies or unscrupulous persons who would ideally say that they're recruiting on your behalf, but ideally they don't have instructions from you to recruit. So this is just a best practice to help protect prospective employees from any kind of data breach. The other best practice is to establish a lawful basis for processing recruitment data. So this ideally requires you to demonstrate that there's a legitimate purpose for which you are collecting this data. This ideally means, like, for instance, you need to comply with the Employment Act, you need to comply with tax laws and those kinds of legitimate basis for processing data. There's also a best practice when you're collecting candidates' data. Try and use secure application platforms. Technology is very important in this aspect. I know it carries a cost implication to it, but it also helps. You in terms of shielding you from any liability that may be forthcoming. We've also addressed purpose limitation as a principle of data protection. So the idea here is to limit the data you collect. Just collect what you require only to avoid any kind of liability. You also need to inform the prospective candidates through privacy notices. Faith touched on this. And this ideally is to help disclose, to help in advancing the principle of transparency in data protection. So, for instance, a compliant privacy notice in this case would have or would contain information regarding what data is collected, the purpose with which this data is collected, the legal basis for processing such data. You also have to inform them who will access this data, and then this is ideally means maybe it's the person's conducting the interview, and if perhaps you want to conduct background checks, you have to inform them that this data is going to be shared with third parties for purposes of conducting background checks. The privacy notice also needs to set up the retention period with which the employer will be retaining this data, and this is especially for persons who have not been successful in their application. If the company is an international company, it's also important that you inform the prospective candidates that there's going to be international data transfer. And you have to ensure, in looking at this, you have to ensure that in the jurisdiction with which you're going to transfer this data, you have to do some due diligence. I'm noting that we are running out of time, but in terms also of retention, I think I've discussed that by defining the data retention periods. We now move on to best practices for employer data for employees, especially in the course of employment. So I've addressed the question of privacy notices. This is not only supposed to be done in the recruitment stage, it's also important that you do it for your employees as well. Now, in the context of human resource information systems, I do realize that sometimes employers tend to outsource human resource information systems. This is systems that probably control leave, they control payroll, they control probably VIPs and all that. And it's important that as a best practice that you input audit trails and activity logs, at least so that we can see who has logged in at what time and what have they done. You can also introduce maybe multi-factor authentication security systems to ensure that you have in terms of security, you are covered in terms of who is accessing your human resource information systems. You also need to conduct regular security updates, regular security checks, because ideally technological systems are prone to any kind of intrusion. So it's very important that we do regular security updates. And we can also have restricted administrator access, in the sense that, for instance, if you want to access a human resource information system, there's somebody who will ideally authorize the person who wants to access. The other thing is employee monitoring and surveillance. I think I've addressed this question. So as a best practice, I think it's important that you ensure that the monitoring that you're doing is proportionate, so that we don't go over and above and intrude into the private lives of the employees. You need to ensure also that the employees are informed of the monitoring. So this is ideally at the point of recruitment, or when a policy such as this one is being introduced. It's important that you inform the employees that the premises is under surveillance. You also have to limit access to monitoring records. So maybe just have a few people, a designated group of people who are persons who kind of review the monitoring and surveillance reports, so that we can try to limit the exposure of that. The other critical aspect is performance management and appraisal. So this is also private information in relation to an employee. And it's important that you ensure that you restrict access in these circumstances and maintain confidentiality. You can have secure physical records. So, for instance, if you have a file room, maybe you can have biometric logs, so that you ensure that there is enough security. Data sharing with third parties, as I've mentioned, there's this sharing of data with the recruitment agencies and background check providers, payroll vendors, and human resource software providers. So in this case, you have to ensure that you have at least data processing agreements with them, which agreements ideally should have confidentiality obligations, so that it becomes something that requires them to maintain confidentiality, and if they breach, a legal liability will arise. And you can also try and do a bit of due diligence and find out what kind of security systems do these third parties have or employ. Now, the last side is best practices post-employment. This is a camouflage of protecting both the employer and the employee. And the first thing is that when an employee leaves, please ensure that you disable the system access, because sometimes because usually there may be a disconnect between in the process of separating with the employee. So it's important that you disable system access, so that such information or the company's information or other employees' information is not unnecessarily exposed. You can use secure email accounts which ideally goes towards ensuring that at least the emails are encrypted and that there's enough security buffer to ensure that the employee data is not exposed. You can also retrieve confidential information. If, for instance, the employee who is leaving had sensitive information belonging to the company, it's important that you ensure that they surrender the said information so that you can be able to protect yourselves and protect your employees' data. Because if you end up not retrieving this confidential information and other employees' data is exposed, there may be liability on your end for not exercising due diligence in terms of handling confidential information belonging to employees. You can also implement structured offboarding checklists. So this ideally is to ensure that employee data is not exposed. So the checklist ideally is to ensure that once the employee is leaving, they've surrendered, for instance, company materials. If they're having like a laptop or an office phone which has data that belongs to the company, it's important that you ensure that you establish this as a policy within the organization. It's also important to coordinate separation between, for instance, an IT department, if you have, together with HR and management. So this is ideally to ensure it's like a layered security check to ensure that once the employee leaves, everything is still secure and other employees' data and the company's data is intact. So that ideally brings our presentation to a close. And we thank you very much for listening to us. And we'll be opening the field for questions, given that time has really gone by. And now we will be able to just take the quick questions. I think there's some that on the chat, we can try and answer them. Perhaps I can hand over to my colleague Brenda to address those. Thank you very much for listening to us.
Oscar, I can
Yes.
go ahead and help you guys sort the questions.
Okay, thank you. Thank you very much, Virginia.
So I think the most pressing question that I've seen is how long should an employer stay with an employee's data? Is it 6 years? Is it 7 years? Is it 5 years? That's, I think, the most pressing question I've seen in the chat. So we can start by answering that question. So thank you for the questions. I've actually seen a number of people have asked that. Depan, Jacqueline, Kinyanjui Nyambura, thank you for raising the question. I'm going to refer you to certain provisions of the Employment Act and the Tax Procedures Act. So I've noticed that a number of members in our audience today have the idea that it's supposed to be for 7 years. So I'm going to start with what I mentioned earlier. So that we were referring to the contents of the contract of employment. If you look at Section 10(6) of the Employment Act, it provides that an employer should retain that kind of information, that is the information contained in a contract of employment, for a period of 5 years. Then the other thing, we have Section 74(2) of the Employment Act as well. So this section, that is Section 74, generally talks about inspections by labor officers. So information that will be supplied for the purposes of these inspections should be retained for 36 months. 36 months, that should be 3 years. And then when you look at Section 23 of the Tax Procedures Act, the provision gives provisions about record keeping for purposes of tax audits and determining tax obligations. So Section 21C provides for 5 years. So basically what this means, from the provisions that I've referred to, you can say that 5 years appears to be uniform as the statutory period for the kind of information that I've referred to for the purposes of our discussion today. So, and I would actually recommend that employers restrict themselves to the provision to the statutory periods. In practice, people may be retaining the information for 7 years, some 8 years, or whatever period they're retaining for, but we are guided by the statutory provisions, because even when there's a dispute, maybe at the ODPC, in courts, courts are guided by statutory provisions. Now, maybe the other, when you look at the Data Protection Act, it doesn't give a specific period in terms of years. So in case there is a dispute around the period in which the employer ought to have retained an employee's information, if you've retained the information for more than 5 years, then it will be upon you to show that retaining it for more than the 5 years was necessary for whatever purpose that you retained the information for. I hope that I've been able to address maybe that question. Maybe the people who asked the question, can I maybe see your reactions in the comment section? It's a discussion we can have. Okay, so in addition to what I've stated, we can assist with the review of your policies to align on the retention periods for different classes of data. As you can see, the law is separating the kind of information. We have information from an employee for the purposes of a contract of employment. We have information from an employee for purposes of assessing the tax obligations. So we can assist with the review of your policies to ensure that you're aligned in terms of the kind of information that you want to retain for a period exceeding the 5 years.
So I think Virginia can take it up from there.
Yes, people in the comment section have said that you have answered it well. Thank you for that, Brenda. Oscar, you can go to the next slide. As we continue answering the questions, you guys can leave your review of how the webinar was in the survey form that we'll share here. You can scan over there. So the next question is, how do you handle a situation where the HR has leaked private employees' data to other employees? Do you sue the employer? Do you sue the HR? Who gets to be liable for that? Oscar, I think you can pick this one up.
This one I'll pick it up. So ideally, the HR, while he's leaking that information, is not doing it in the course of the employee, in the course of their duty as an employee. You see, now in that case, I believe it would be wiser to sue the HR, because it's generally not accepted that the HR person is authorized by the company to leak an employee's information. So that one you have to go and attach liability on the human resource personnel, because they're actually acting out of their scope of their duty. So that's where liability would attach. The only issue, perhaps, if I may add, is to probably maybe where liability may slightly attach on the employer is perhaps if they are not diligent enough in terms of protecting their data. But if they can demonstrate before the Data Protection Commissioner that they put in place all the necessary security measures to protect employees' data from being leaked, then you can be able to defend yourself on that ground. But when it comes to a HR employee, when they do that, they're actually acting in law, what we call a frolic of your own. They're not acting under the instruction of the employee of the employer to leak employee data.
Okay, Oscar, thank you so much for answering that. The next question is it right for an employer to request pay slips from the previous employer? Like when you're going to an interview, then they ask you for your previous employer's pay slip.
that is not, that's sensitive personal data. You can, like, an employer cannot request for an employee's previous pay slips because it doesn't, like, it's not feasible. It's not data that is required for the job that they are going into. So in terms of pay, that is now a negotiation between the prospective employee and the prospective employer, but the employer cannot request for pay slips from the previous employer. They can maybe request for tax compliance and all that, maybe credit listing with the credit reference bureaus, but they cannot ask for an employee's previous pay slips.
Okay, next question. What about the requirement of where there is need for a background check, where a prospective employer asks for information from the previous employer, yes, who does not have your authority to share their data and how much information you are sharing?
Virginia, I didn't get the question. Can you come again?
What about the requirement of background checks where a prospective employer asks for information from the previous employer who does not have your authority to share their data, to share your data? I think he meant that, to share your data and how much information you are sharing.
Okay, so a previous employer can only share your information with your consent. So if they are going to supply this information, they ought to first reach out to the employee, that is the former employee, who is the data subject, and seek their consent to share the information with the prospective employer. And then again, on the issue of an employer requesting for pay slips from the previous, give me a moment. Oh, the issue of an employer requesting for pay slips from a previous employer. Again, the issue of consent comes in place. So if as an employee you've been asked to supply the, you're aware that your current employer requires, or maybe a prospective employer requires pay slips from the previous employer, you can give your consent for them to supply the information to your prospective employer. And you still retain the right to decline to give the consent for them to supply the pay slips. So you can choose to look at it from the angle of whether it is right as the participant has asked, or from the consent perspective.
And maybe just to add on the question on background checks, again, I said one of the best practices during recruitment is you need to inform the prospective employee that you're going to perform certain background checks on them, and that will form the basis of perhaps making all these inquiries in terms of background check providers. So it's very important that the employee is in the know that a background check is being conducted on them. Yeah.
Oscar.
Yes.
Just to add on what you guys have put forth, I've actually seen a very good practice, even when you're advertising during the job advert, you insert a line that say that for the successful candidates for this position, we shall be conducting reference checks, so that we have it from the word go.
Thank you. Thank you very much, Faith, for that. Virginia?
Virginia, I've also seen a question by Michael Orlando. So he has mentioned the Peter with Federa case, I believe, whereby there is a decision restricting the public warnings, whereby you have the photo of an employee, and you're basically warning the public that maybe you're informing them that they are no longer an employee of the organization, or that maybe people should refrain from dealing with them with respect to an organization. So basically, when there's a decided decision, that becomes the law. And there's a post that I came across on LinkedIn by Stanbic Bank Kenya. So they have actually implemented that decision in terms of how they are issuing these public notices. So basically, the statement doesn't have the photo of the employee who is trying to impersonate the chief executive officer. It doesn't give their names, but it just wants the public. It's a disclaimer. Actually, it's titled Public Statement, Clarification on False Leadership Claim. Stanbic Bank wishes to clarify that social media posts by a former employee claiming to hold the position of chief executive officer are inaccurate. The bank's chief executive remains in office and the bank's leadership and governance structures remain unchanged. So you can see how they have been able to put in place a measure to comply with that decision. So basically, and in my opinion, it's a good way because you can see that the affected employee or former employee doesn't stand the chance of coming after the bank to sue them for data breach or any allegations around breach of their personal data. So I think that answers Michael's question. Maybe we can proceed.
Yes, thank you, Brenda. There's also a question of, can an employer maintain a CV database and for how long should the database be retained?
Maybe I can take that. I know there are some circumstances where an employer may retain prospective applicant CVs with the aim of perhaps when there's a vacancy that is going to arise later, they can be able to make reference to those CVs and perhaps recall those candidates who were not, for instance, not successful in their application. So in this case, you also need to inform the candidates you need to inform them that you're going to keep their CVs for a certain period of time, and you have to explain the retention period. And most importantly, also you have to obtain their consent, and this is probably through the application and recruitment process. So it's very important to maintain that period. But because probably you are not retaining that information for maybe for purposes of compliance with the employment laws, I think it would be safe to go the section 72 subsection 2 of the Employment Act and probably consider keeping it for a maximum of 36 months. So that would be my recommendation. It would be more of a safety net in terms of protecting you from liability because you have stuck to the statutory time limit that has been provided for in the Employment Act, given that recruitment and onboarding is an element of employment.
Okay, thank you for that. There's a question here, post-employment data protection. The Data Protection Act came in force in 2019, and the above cases relate to 2016. You can fact check that for us. Please explain what Kenya was using in absence of the Data Protection Act.
Ideally, before the Data Protection Act came about in 2019, our Constitution ideally accepts international treaties as part of our law. So ideally, the treaty that was in force at that time, I think, is the GDPR, and that is what ideally the law our country used to apply in terms of our laws.
Okay, in addition to what Oscar has said, so before 2019, we were mainly guided by the Constitution of Kenya, and specifically Article 31, and other sectoral laws. We have, for instance, the Kenya Information Communications Act, the Consumer Protection Act. We didn't have a specific framework governing the data protection space in the country. Oscar has mentioned the General Data Protection Regulation, which is an EU regulation, and this regulation has actually informed the substance of our Data Protection Act in so many aspects. So best practices at the time were borrowed from that specific regulation, and these other fragmented sectoral laws like that I've mentioned alongside our Constitution.
Thank you very much, Brenda, for that. Can take the next question.
Yes, we really try not to go past 11, so we are going to try to answer as many questions as we can. So I think on background screening, we've talked about it, the Peter Waithera case and having to warn the public about an employee. Brenda has addressed that. Is consent an appropriate legal basis? Okay, no, there's this other one. Is it legally appropriate to allow an exited employee's email account to be accessed by an incoming replacement or an internal staff member? If yes, are there any legal risks involved?
If it were in answering that question, if the emails were related to work relations, you see there has to be continuity of business. So if the email was in relation to if the email was an official email for the company, then there is nothing that exposes the company to liability, because this is ideally just the company's information. They've brought in a new employee to replace another. And in terms of business, there needs to be like a seamless transition to the new employee. So there's no liability that would attach on this question, because the data was already, part of the employment contract. So there's no liability in this case that would attach on the employer.
I, however, have to state that the scenario changes if the employee was using a personal email for work-related matters. But if we are talking about an employer domain, then like Oscar has said, legal liability does not attach, because the assumption is you're not using an employer's domain for personal work. But where you're using your personal email for work-related matters, then liability may arise if the employer now tries to demand that the employees in the company should be able to access your personal emails. So it's something that I think can be handled during handover, such that we don't have to deal with such a scenario.
Okay, yes. Faith, if you see you can answer any of the questions that I am asking, you can go ahead and unmute and answer. Okay, so the next one is consent an appropriate legal basis of processing employee data, taking into considerations: 1, consent must be freely given and rarely is at work because of the power imbalance that exists. 2, the illusion of choice. 3, the withdrawal problem.
Come again in terms of the considerations, the power imbalance, then?
Actually, can you just read the question again? I think I got lost somewhere along the way.
Okay, is consent an appropriate basis of processing employee data, taking into consideration: 1, the consent must be freely given, but it rarely is at work because of power imbalance. 2, the illusion of choice. And 3, the withdrawal problem.
So this is a very dicey area, and I appreciate where this question is coming from in terms of that power imbalance between an employer and employee, because ideally when you get a contract and you find this kind of consent clause for using your data in the contract, you feel kind of compelled, because you're not freely given your consent. You feel kind of compelled to sign, because at the end of the day, you are a job seeker and you would like to continue advancing your career. So in terms of this illusion of power imbalance, you see, it's more about how, as an employee, you're able to negotiate with your employer and probably explain to them why you're not comfortable with probably your photos being used in marketing materials, and for all your photos being used for marketing purposes. And I believe a considerate employer would make sufficient accommodation for that, but it's just a matter of negotiation between the employee and the employer. Perhaps Brenda would like to add on to that.
Yes, so again, the issue of consent is highly regulated by the Data Protection Act, as well as the GDPR, that is the General Data Protection regulation, which we have mentioned. And there are very strict requirements on how consent should be sought from the employees and generally from the data subjects. So an employee is supposed to request for consent in a manner that is clearly distinguishable from other matters in an intelligible and easily accessible form using clear and plain language. So you can only seek consent for one action at a time. You're not supposed to lump up a number of issues from such that the employee is not able to really tell what they are consenting to. So if you're seeking maybe consent to use material for advertising, make sure it's very clear and the employee is not confusing this consent from other aspects that you may be, from other issues or purposes for which you may want to process their personal data. Then again, the issue of withdrawal of consent, actually, that's a right that employees and data subjects in general have. Consent can be withdrawn at any time. And it's actually interesting that when you're signing a contract, there might be a clause that generally says you've consented to the use of your maybe images in marketing or such things. But the moment that an employee expresses withdrawal of this consent, that should be upheld by the organization, and processing of the information should actually cease. While we appreciate the imbalance of power between an employer and the employee, liability can actually arise for an employer where they don't honor an employee's request to withdraw consent, because it's basically an employee's right. So I think that's all I have to say with respect to that concern. Maybe we can proceed to the next question.
Okay, due to the interest of time, we'll answer only 2 more questions and I'm going to share them all at once. So how about CCTV footage for organizations that monitor employees? Is that employee data and how should that be stored and accessed? The other one is what procedures are followed if there's a data breach involving employee records?
So I'll start with the question on CCTV footage. See, the employer needs to establish a legal basis for, of course, this is employee data, people's footage or image is employee data. But if the employer is processing this data for security purposes, then that's a lawful basis for, continuing with monitoring and surveillance, because for security purposes and for instance, if it's fraud prevention, and that forms a legitimate basis for processing this kind of information. I don't know if perhaps Brenda would like to address this question a little bit more.
Again, there is the issue of notifying your employees. I'm sure when you've gone to maybe some of the, even let's talk about maybe a restaurant, like a number of restaurants, they have notices that the premises is under CCTV surveillance. This, however, does not amount to consent in law. Again, the issue of consent is very important because people have to consent to surveillance. And something that I mentioned with regards to the processing of sensitive personal data, like when the organization is involved in large-scale monitoring, there are obligations that come with such monitoring, because CCTV monitoring would easily fall into that category. So an organization has to put in place measures to make sure that it complies with, it has put in place technical measures to make sure that even the monitoring is compliant with the data protection laws. because failure to do that, then liability arises despite putting on notices that the premises is being mentioned. And also sometimes even consent can be disputed depending on how that information is managed. Again, the issue of for how long do you retain the information captured by the CCTV, it's again governed by the Data Protection Act, which states for no longer than necessary, for no longer than necessary. So so this is actually very quite ambiguous, and in case of a dispute, it's a matter that could be very controversial in terms of how the courts are going to interpret the same. So to make sure that the organization is covered, you just need to put in place measures, put it in your policies, seek the consent of the employees to make sure that there are no loopholes that can expose the organization to lawsuits or other forms of legal and financial liabilities.
Okay.
Is there another question?
Yeah, I think there was another one last question.
Yes, on like the procedure when a data breach happens with employees' data.
So
But I think
ideally,
it's already 11, so I think we will have to close because we are way past time, 30 minutes. I'm so sorry for that, guys. We have to close. Thank you so much for attending this webinar. We also want to say thank you to KNCCI for being able to partner with us to host this webinar. You can leave at your own pleasure. Thank you.